Welcome to the Right Word with Taro. People tend to describe litigation as a traditional form of dispute resolution. And so the first thing people do when they have issues is most likely to file a lawsuit in court. Today we'll be discussing alternative dispute resolution with focus on mediation. What is mediation? This is a structured open communication process where a neutral third person helps parties to a dispute find an optimal solution. Now, the decision is entirely reached by the parties. I think mediation is even the older form of dispute resolution. In the Nigerian context, we all recall back in the days when traditional rulers and village council resolved disputes. Now, they did it effectively and still managed the emotions of the parties to the dispute by not imposing decisions on them, but guiding them to make the best decision. Mediation is very relevant today as it has become mandatory under some jurisdictions for parties to a dispute to seek pre-action counseling before issuing court proceedings for settlement on civil matters. Now, even the court recommends amicable resolution of disputes at the instance of parties. Most states in Nigeria now have a multi-door courthouse where you can walk in to get services like mediation. Even the judges are now being trained on alternative dispute resolution methods. Let me make clear some of the cases you can resolve through mediation. First is business and commercial disputes. This is very important for business owners and even startups. Whether you're operating in a local market like Ogbogonogo if you're based in Asaba or Balogun market if you're based in Lagos, bear in mind that as you run your business, certain disputes may arise, and so it is vital for you to have a dispute resolution strategy. Mediation could be an option for you, and so ensure to incorporate a dispute resolution clause in all contractual agreements. This is very helpful in the event of disputes. We also have landlord and tenant disputes. Did your tenant refuse to pay rent? Or maybe it is even the landlord that is not fulfilling contractual obligations. All these can be settled through mediation. We also have labor disputes. Human resource managers have considered mediation as an effective way of addressing workplace disputes. The relationship of an employer to employee and between colleagues is very important in the workplace, and that is why disputes must be resolved quickly. Problems relating to management, work performance, discrimination, and undue termination could all be resolved in workplace mediation. Why mediation? It is a well-acknowledged fact that time has value. The moment you think about starting a proceeding in a Nigerian court, that is the day you have to be baptized with the spirit of patience. The court relies on procedures, and sometimes these procedures take longer than expected due to adjournment, absence of counsel, or witnesses that won't stop giving excuses. There is no doubt that the court is the hope of the common man, and I have utmost respect for the court. The legal system is, however, broad with different resolution methods. And so litigation is not the only option available for you to attain justice. It is the court of justice and not the court of litigation. Now, how does mediation help the parties build an agreement? In mediation, a judge does not impose the outcome. This is therefore persuasive for all parties to reach a conclusion that reflects their needs without losing a fight. It also saves time and prevents court adjournment of litigation, which is even more expensive. The flexibility is what attracts people to this type of dispute resolution. Positive benefits of marketing mediation. One of the positive benefits of this form of ADR is that it is a fast resolution method. I have stated this earlier. And it also tends to preserve an ongoing future relationship of disputing parties. The lesser cost of mediation in comparison to litigation is another advantage in marketing mediation. Also, there is so much flexibility regarding venue, and this makes disputing parties free from a confined court if they want to. The issues regarding emotions are adequately managed, and the outcome is strictly voluntary. Nobody will force anything on you. You get to agree on the terms that is suitable for the situation. So before you say to someone in an anger tone, "You will hear from my lawyer," or "will see you in court" as a form of litigation threat, take a deep breath and be open to other forms of dispute resolution. Save your money, save your time. Thank you for being here. Don't forget to subscribe so you get a notification when next I upload a video.